Good evening and welcome everyone. I start by acknowledging the Wurundjeri people as the traditional custodians of the land I speak from. I pay my respects to their elders past and present. And at 5 weeks from the referendum, I personally want to express my hope that we Australians will come together to formally recognize our First Nations, giving them a constitutionally guaranteed space to have a say about the public policies that directly affect them. So thank you everyone for joining us here for what I'm sure it will be a very interesting event. Not too long ago, artificial intelligence was something from the future, with an aura of science fiction, one could say, but not anymore. Artificial intelligence seems to be everywhere, which is both exciting and terrifying. In the case of government decision-making, which is our focus tonight, how much should it be trusted to artificial intelligence, if any? The allure of AI is undeniable. Efficiency, precision, and the absence of human bias, perhaps? But what about a more nuanced understanding of the human condition? Isn't that important in government decision-making? Can algorithms replicate empathy, compassion, and understanding towards those in more vulnerable positions? Public governance, after all, extends beyond numbers and data. Or can we work for a future where computational and human minds work in harmony, amplifying the best of what both have to offer? Tonight, we have the privilege to hear from Associate Professor Yee-Fui Ng on this fascinating topic. Yee-Fui is an Associate Professor in Law and Deputy Director of the Australian Centre for Justice Innovation at Monash University. Her research is on the intersection between public law and politics, focusing on enhancing executive accountability. Her published works include The Rise of Political Advisers in the Westminster System and Ministerial Advisers in Australia, The Modern Legal Context, which was a Holt Prize finalist. Please welcome Associate Professor Yee-Fui Ng.
Thank you very much, Fernanda, and it's a great pleasure to be here this evening. So I'm going to talk a little bit about my current book project, which is my third book, and it's created some pain and suffering in my life, but I will distribute my pain and suffering along and share what I found so far. So my book's about automated government decision-making, comparing the US, UK, and Australia. And we know that artificial intelligence and machine learning have enabled widespread automation of government decision-making in Australia. Yet vulnerable populations have been very seriously harmed because of the difficulties that they face in challenging automated decisions. We know in Australia, the Social Security automated system Robodebt erroneously identified overpayments deemed to be owed by Social Security beneficiaries. Errors of methodology led to inflated debt calculations for over 600,000 individuals. Desperate people falsely accused of high debts rang the Social Security Agency Centrelink, only to be put on hold for 8 hours. These incorrect calculations have led to grave repercussions for vulnerable, low socioeconomic debtors, including individuals experiencing severe mental health issues and even suicide. In 2019, the federal court held that the basis for raising debts under the Robodebt program was irrational and therefore unlawful. Following this, the Australian government agreed to settle a class action on behalf of 600,000 people affected by Robodebt for $112 million without any admission of liability. The judge presiding over the case decried the Commonwealth's handling of its online compliance system as a very sorry chapter in Australian public administration. So the Robodebt Royal Commission lambasted the scheme as an extraordinary saga of venality, incompetence, and cowardice. Yet this is not an isolated incident. All the way across the globe in Michigan, Republican Governor Rick Snyder, a former venture capitalist who vowed to run government like a business, decided to put into place a new automated social security system. Unemployment agency staff were laid off to achieve cost savings, and in their place, a $46 million automated fraud detection system was introduced in 2001, the Michigan Integrated Data Automated System, or MIDAS. MIDAS was programmed to treat any data discrepancy as evidence of illegal conduct and to trigger an automatic default finding against individuals. The program has been a windfall for the Michigan budget line, collecting over $60 million in just 4 years, bringing the state budget back into the green. However, it turned out that the AI system had a 93% error rate. As a result, between 2013 and 2015, the system falsely identified more than 40,000 Michigan residents of suspected fraud. It seized their tax refunds, it garnished their wages, and imposed civil penalties for 100% the amount the person was owing, plus interest. These people wrongfully lost access to the unemployment benefits and faced fines as high as $100,000. As a result of being wrongfully accused of unemployment fraud, 1,100 people filed for bankruptcy. They lost their jobs, they lost their homes, they lost their livelihoods. With a quadruple penalty plus interest, people went into significant debts. As their credit ratings plummeted, there was a stain on their record for 7 years. Consequently, they were unable to get jobs, rent houses, buy cars or homes, and a couple of people attempted suicide. In a 2017 settlement, Michigan's unemployment agency agreed to stop using MIDAS's automated functions without human review. The settlement also made the agency reverse and refund certain fraud determinations. In 2022, the Michigan Supreme Court ruled that people in Michigan can sue state agencies for monetary damages for violating their constitutional rights. In the UK, there was the post office scandal, where 736 sub-postmasters were wrongfully prosecuted for theft, fraud, and false accounting for their branches. So these are the people running the post offices. This was between 2000 and 2014. The Post Office Limited, a wholly owned British government company, aggressively pursued these sub-postmasters through the courts, resulting in numerous criminal convictions, at least 4 suicides, some being jailed, including a teenager and a pregnant woman, and many facing bankruptcy and financial ruin. However, none of them had done anything wrong. The Horizon accounting software system designed by Fujitsu had produced incorrect accounting shortfalls due to bugs, errors, and defects in the IT system that had automated the post office network. Widely decried as one of the biggest miscarriages of justice in British history, this multi-million-pound IT disaster has spanned over 20 years and has generated widespread condemnation. A question that immediately arises is, how did things go so wrong in these advanced liberal democracies with their sophisticated bureaucracies and well-developed systems of checks and balances? For each of these large-scale catastrophes to occur, Deliberate choices were made at key decision points by elected politicians and public servants to procure and deploy faulty technology at a large scale on vulnerable populations. Hundreds and thousands of people were harmed for years due to these very harmful government decisions. We saw in the Robodebt Royal Commission that the department had legal advice from 2014 that the scheme was unlawful, but yet there was a deliberate and orchestrated campaign by ministers, ministerial advisers, and senior public servants to conceal the scheme's illegality over more than 4 years and to undertake a media campaign to smear any welfare recipients who complained. Consequently, although the unfairness, probable illegality, and the cruelty of the scheme was apparent from the beginning of 2017, the scheme still persisted till late 2019. These scandals demonstrate the need to more closely scrutinize the regulation of automated decision-making across government, including how the system is designed, how AI technologies are rolled out, and whether appropriate auditing practices are put into place to mitigate any ill effects. My book, therefore, examines the legal, political, and managerial controls that are needed to prevent large-scale AI disasters from occurring. So AI interventions in social security are deployed experimentally and punitively and has caused significant harm in various jurisdictions, including Australia, the US, the UK, and the Netherlands. Welfare recipients have been used as test populations for technologies of state surveillance and controls. These invasive technologies have been first deployed on vulnerable populations before being rolled out to the broader population. In this talk, I will explore the legal challenges to automated government decision-making in the US, UK, and Australia. The litigation comes from different angles in each jurisdiction: constitutional due process in the United States, human rights and judicial review in the United Kingdom, and administrative law in Australia. There are three main forms of challenging government AI decision-making: challenges to the input, the output, and the use of the data. First of all, a person affected by AI decisions could challenge the inputs to the decision-making in terms of faulty code or data. The person can argue based on anti-discrimination principles that the data inputted into the AI system is biased and produces discriminatory outcomes. Another method is to challenge the outputs or the results of AI decision-making. If they can show the computer produces decisions that are substantively flawed, and this can be done through challenges of the rationality of the decisions in the UK or Australia, or due process in the United States, which considers the relationships between inputs and outputs of government decision-making. Finally, another avenue is to challenge the use of the data in terms of data sharing and retention. A person can claim privacy protections in the government's use, dissemination, and retention of AI data. This talk will focus on the legal challenges based on rationality. So a major legal avenue for challenging automated government decision-making is based on rationality. The legal system is predicated on the assumption that decisions are made by human administrators based on the concept of human rationality. Therefore, decisions made by computers that fail this concept of rationality can be subject to legal challenge. The use of AI in welfare in Western jurisdictions has been plagued by problems of inaccurate or irrational determinations. For example, an algorithm used by the Department of Human Services of Arkansas would determine a foot amputee had no problems with his feet despite lacking a foot. So problems with rationality. So there's three main areas of concern in terms of reviewability. So first of all, what is a decision? Second, who is the decision maker? And thirdly, what are the grounds to challenge the validity of a decision? So first of all, what is a decision? In determining what a decision is, the United Kingdom has adopted the public function approach based on the data fin test, meaning the key issue is whether the body is undertaking a public function, which would make it immaterial whether the decision is undertaken by a human or an AI. In the US, the focus is on the impact of decision-making on individuals. That is, decisions that impact on a person's life, liberty, or property, with a generous interpretation of the term property that encompasses welfare benefits. This empowers individuals to constitutionally challenge government AI decisions that affect their fundamental rights. It has not been fully tested in Australia, but it appears that Australia is interpreting statutory judicial review under the Administrative Decisions Judicial Review Act by reference to the process of decision-making. The majority decision in Pintarich requires that a decision involve a process of deliberation. As the dissenting judge noted, this may exclude automated decisions from its ambit, as AI decisions lack a process of deliberation, and this may thus preclude statutory judicial review of agency decisions. Australian constitutional review under Section 75(5) hinges on the identity of the decision maker being an officer of the Commonwealth. And this may create issues for AI-made decisions where the decision is wholly made by a computer. However, this may potentially be cured by a legislative provision that deems a decision made by a computer to be made by a minister or senior government official. Therefore, the UK and US have a formulation for judicial review that is conducive to challenging wrongful government AI decisions, while Australia's approach may lead to issues in terms of reviewability. The second question is, who is the decision maker in an AI decision? There has always been a presumption that an administrative decision will be made by a human, so that will be a responsible party. In the case of AI-assisted decisions, where technology is used in the process of making a decision, this should not be an issue, as ultimately there will still be a person at the end who is clearly the decision maker. When it comes to fully automated decisions, however, it becomes less clear. One option is to borrow from the European Union General Data Protection Regulation, or GDPR, and only allow for fully automated decisions in certain circumstances, such as when it's necessary to enter into a contract, is authorized by a law that provides the suitable safeguards of the person's data, or is based on the person's explicit consent. A further method of ensuring that there's a designated responsible party is by inserting legislative deeming provisions. These are sections in legislation stating that a decision made by AI technology will be deemed to be made by a minister or senior public servant. So providing a responsible person for AI-made decisions facilitates judicial review and enables accountability over AI decision-making. Finally, there is a question of the comparative grounds of judicial review across the jurisdictions. In Australia in 2019, the basis for raising debts under the Robodebt program was held to be unlawful. In a test case by a debtor subject to a Robodebt, the federal court in consent orders in Amato and Commonwealth held that automated decisions made on the basis of income averaging alone, that is the Robodebt method, were irrational and therefore unlawful. In the case of Routledge and Commonwealth, as mentioned before, the government agreed to settle a class action on behalf of 600,000 people affected by the Robodebts. The Commonwealth government admitted that it did not have a proper legal basis to raise, demand, or recover asserted debts which were based on income averaging from ATO data. As a result, the court found that the debts issued were ultra-vires, that is beyond power, and unlawfully incurred on the applicants on the basis of a mistake of law. The Australian court's approach in Robodebt is focused very narrowly on the methodology of the decision-making that produced these inaccurate debt notices, rather than its substantive impacts. This means that future automated decisions made on the basis of different data points may be held to be valid. By contrast, the approach of the UK courts holds a greater promise for success in judicial review for vulnerable claimants, as it focuses on the merits of the rule and its substantive impacts. The UK framework combines domestic judicial review with international human rights conventions incorporated into domestic law. Therefore, in addition to judicial review, the UK courts will consider human rights grounds of the European Convention of Human Rights, or ECHR, which adds to the scope of review in terms of anti-discrimination and privacy. And this allows for a broader scope of legal challenge of government action compared to Australia. In the Secretary of State for Work and Pensions and Johnson, the UK Court of Appeal invalidated part of an automated system used to calculate universal credit payments. The automated system did not accommodate the fact that people who were paid their salary on a particular day each month will be paid on a different day if their usual payment date falls on a weekend or public holiday. This caused major fluctuations in the welfare payments received. The problem impacted a particularly vulnerable group, those who were on low incomes undertaking ad hoc employment. In this case, the plaintiff was a single mother who was at risk of eviction due to the major fluctuations in welfare payments and lack of cash flow. This led her to borrow money just to purchase food. One of the welfare recipients, who was also a single mother, reported that the system of fluctuating payments led her to go deeper and deeper into debt, and she felt so desperate that she attempted suicide twice. The Court of Appeal invalidated the relevant part of the automated process and found the regulations to be irrational and therefore unlawful. This was because the issue had a dire impact on 85,000 vulnerable citizens and led them to suffer consequential financial stress. In addition, the court found that the processing of claims was arbitrary and claimants were not alerted by job center staff to the problems that they would face if the end date of their assessment period coincided with the day in the month on which their salary is paid. Another basis of irrationality was that the system in effect operated to disincentivize work, contrary to the legislative policy. The system created an incentive not to work to receive a stable income or to look for a job where the salary pay date did not coincide with the end of the assessment period, which may take priority over accepting a promotion or a higher paying job that made use of the claimant's skills and educational achievements. Indeed, one of the claimants refused the promotion because of the payment conditions. Therefore, in its decision, the UK Court of Appeal was willing to consider substantive issues relating to the actual impact of the rigid rule on vulnerable populations and whether the AI rule achieves its policy goals. These led to the finding in Johnson that the minister's decision met the very high bar of being when-spree unreasonable. That is so unreasonable that no reasonable decision maker would have come to that decision. In the US, automated government decision-making has been successful on the grounds of procedural due process, which considers whether the government has followed the proper procedures when it takes away life, liberty, or property. For example, in the case of Michael T. Bowling and Bowling number 2, a group of West Virginians with severe intellectual and development disabilities brought an action against the state's Department of Health and Human Resources, challenging the state's reliance on a proprietary algorithm to reduce Medicaid benefits, which was administered by APS, a private company. The district court found that the APS algorithm did not satisfy the American Constitution's due process requirements, as the government had not provided any information that were about factors that were incorporated into the algorithm, how each factor was weighted, and the overarching methodology employed. The court also criticized APS for not providing an individualized rationale for the budgets allocated to the plaintiff, making it impossible for the plaintiffs to meaningfully challenge the budgets. The court concluded that APS decision-making process created an unacceptable risk of arbitrary and erroneous deprivation. As a result, the West Virginian government developed a new system containing matrices with clearly identifiable variables that would be publicly available. The court concluded that the new system sufficiently remedied due process flaws and lifted the injunction. In general, due process claims in the US have been successful on the basis of insufficient notice, explaining why the AI tools analysis led to a reduction in benefits, which then created the risk of determinations being arbitrary and capricious. And when the algorithm is used in decision-making, US courts have recognized that individuals affected have to be provided with sufficient information about the decision-making process to ensure that the automated decision is rational and accurate. Therefore, in the US, the focus of the cases is not just on the accuracy of decision-making as exhibited in Australia and the UK, but also on broader transparency requirements. American due process claims provide safeguards to ensure that there's some degree of disclosure of AI methodology. Although the due process right is flexible according to context, the minimum level of disclosure seems to be the static factors relating to the AI methodology. Some cases require disclosure of the individualized basis of the decision concerning the person affected. These public disclosure requirements enhance the transparency of AI systems in the US in providing the claimants with sufficient information to ascertain whether there have been any flaws in the decision-making process. However, the level of information provided varies and has been criticized as insufficient in some cases. For example, in State and Loomis, the Wisconsin Supreme Court upheld the use of a controversial algorithmic predictive sentencing tool, Compass, by judges. So this decision-making tool is used in various US jurisdictions to predict which convicted offenders pose the highest risk of reoffending. So it's a pretty controversial use of the technology to predict the risk of recidivism. However, it's not known how precisely the Compass risk assessment tool performs this task. And this is because the tool itself and the algorithm upon which it's based remain a trade secret. Nevertheless, the Supreme Court of Wisconsin approved the use of such tools, providing the judge did not fully delegate their decision-making function and still considered the defendant's arguments on the question of future reoffending. A positive feature in the US is that AI litigation settlements or decisions may include an ongoing system of monitoring and supervision by the courts for several years following the decision at the discretion of the judge. This leads to continually negotiated outcomes between the plaintiffs and government about the implementation of AI systems. For example, in a case settlement for an automated decision-making formula for Idaho's Medicaid program, a roadmap was developed for how the state would fix the formula and provide a suitable representative for individual recipients. Over several years, the state had to provide information and updates on its progress in amending the formula to the court with consultation with the affected parties. This system of continual supervision after a decision is an additional form of oversight that ensures the government implements adequate changes to AI systems. Therefore, it can be seen that automated government decision-making has been successfully challenged by way of judicial review in the US, UK, and Australia. In the US, the challenges have been based on procedural factors, such as the level of information provided about AI systems. By contrast, in the UK and Australia, the substance of the decision is material, that is, whether the automated decision can be justified. However, the formalistic approach to legal interpretation in Australia that focuses on the process of decision-making and the nature of the decision maker is more likely to hamper legal challenges. On the other hand, the UK's broader rights-based approach that considers substantive issues relating to the impact on vulnerable populations and whether the AI rule achieves its policy goal is preferable to enable individual redress. The American concept of due process allows individuals to prise open the bonnet and obtain disclosure of details of the AI system. This, coupled with a proactive system of continual monitoring by the courts, allows for a strong possibility for changes and corrections to government AI systems. To sum up, governments in liberal democracies have jumped onto the AI bandwagon and have been enthusiastic adopters of new technologies. However, the use of automation in government has been trialed and deployed punitively on the most vulnerable sections of our society to predict and punish criminal recidivism and unemployment fraud, and to automate social security debt notices rather than to predict insider trading by the wealthy. The then United Nations Special Rapporteur on Extreme Poverty and Human Rights, Professor Philip Alston, warned about the risk of the digital welfare state, where digital data and technologies are used to automate, predict, identify, surveil, target, detect, and punish. In this context, it is time to seize the gauntlet and address one of the most significant problems of our time: how to ensure that automated government decision-making is implemented in a fair, effective, and accountable manner without harming vulnerable citizens. So thank you very much, and I'm happy to take any questions.
Oh, thank you. Thank you so much for this. I've been trying to follow some of the comments for the questions. So perhaps to start, there has been a few comments here asking about, is there a difference between AI and automation?
Yeah, sure. Yeah, so basically, what we saw in Robodebt is not technically AI, it's just automation based on a rules-based system where you give a certain rule and the result comes up. Whereas I was fortunate to visit the US last year on a Fulbright scholarship to NYU. And what we do see there is a very, very large scale use of AI all across government. And that's not just the automation that we see in Robodebt, the rules-based system, but also predictive technologies. So some of the examples I talked about, they're trying to predict future behavior, like who's likely to reoffend, and it gives that person a score, and judges make a sentence based on that score that they get from the AI system. And this is a risk that might happen in Australia. We don't have that level of AI technologies in government so far. But if you look at the US, the whole of the government's using predictive AI all throughout the criminal sentencing process, from bail to the judge imposing the sentence. They're using AI to do that. And we're seeing the use of predictive AI and machine learning happening more in the UK as well. So if the other advanced liberal democracies are example of what can happen in the future, we do have to be quite mindful of how we regulate the use of such technologies.
Yes, we had, thank you for that. We had a few comments about how broken our public service is. And I guess that goes hand in hand with the eagerness of the government to start using AI. So we have broken the public service that would make using AI even more appealing. And if we take, those are comments, if we take out automation, we would need to increase the size of the Australian public service by an order of magnitude that wouldn't appeal for most governments. So can we avoid this process?
I think that
should we?
Yeah, I think that automated systems are here to stay, and governments have been super enthusiastic about adopting these technologies. First of all, is that idea of fetishization of technologies, and also they want to be number one in developing AI. It's quite fashionable. So like in the US, they go, oh, we want to be number one. We've got Silicon Valley. We want to be the top developer of AI. And in the UK, they go, oh, we want to be top 3 on developing AI. In Australia, they, oh, we want to be top 10 in developing AI. So there's a very strong appetite for being a pioneer in this system. And they do try to deploy it within government systems. And yeah, people have raised very important issues about the big problems that we have in the public service, and the Robodebt Royal Commission illustrated this very blatantly, that the public servants did not give any frank and fearless advice. So they're not performing the roles that they used to be. They're afraid. The senior public servants are now on fixed term contracts. Ministerial advisors have become very powerful. The public service has become very weak. And as a result, Robodebt, the whole Robodebt Royal Commission shows that there's a real problem and fundamental weakness in our system of public administration. And that's not going to be fixed by just putting a whole bunch of computers in. There needs to be a cultural change, and also appropriate safeguards in our use of technologies, and also, yeah, just a recalibration of the power of ministers and ministerial advisors, and the power of the public service, which has been diminished.
Mike Heat has a question about the responsibility of regulation. Would you like to make that question yourself, Mike? You can unmute and ask directly.
Yeah, thanks very much, Yee-Fui. Look, I'm just really interested in what bodies or institutions in Australia have the responsibility for overseeing AI regulation, and whether they're effective enough, or what areas do you think they need to be strengthened in?
Yeah, that's a really good question. And right now, we don't actually have very strong government leadership in terms of AI. So like certain countries like the US and UK have dedicated AI regulators. In Australia, we do not. The Department of Industry has shown some interest in producing discussion papers on how to regulate AI. What I think needs to be done is a combination of legal, political, and managerial controls. So by the time you get to the courts, it's in a sense too late, like hundreds of thousands of people have already been harmed by the AI technologies. So I think that the regulation has to come right from the beginning in the agencies themselves. So the agencies have to impose managerial controls about how they design, how they procure, how they develop, and how they implement the AI technologies or automated technologies. Because what we can see from overseas, they can put in a process of impact assessment, so assessing the impact of these technologies on vulnerable people. They can put in systems of auditing, performance management, auditing samples of the decisions to see whether they are accurate or whether there are any issues. And I think these controls are needed right from the very beginning, and we don't have that kind of system in Australia so far. We do need to put that into place. So the agencies themselves go through this process of assessing whether the use of technologies might harm people, what changes they might need, consultation processes, and so forth. Of course, there's the system of political controls that we already have, like the Ombudsman, the Auditor General, Information Commissioner, and tribunals, that kind of thing, that the other form of regulation.
I might have missed it, but so is there any legislative, currently any oversight in current federal legislation?
No. Yeah, we're a little bit behind in terms of regulating automated government decision making. So that's why I'm writing my book, and I'll push for reform, because I think that it's going to become increasing part of government, and we do need to put in the relevant safeguards, because it's not been deployed very well in terms of the design and implementation so far.
Brett Osler also made a question here about which place has the highest standard. Do you want to make that question yourself, Brett?
Yeah, you pretty much covered. So in terms of medical equipment and the like, the EU is often regarded as the highest bar to pass, and then, you know, something like the US. So is there a state or a region that you're aware of now that does have that highest bar, and are there improvements that we could make to that for Australia?
Yeah, certainly we can look to overseas to good examples. So in terms of data protection and privacy rights, the EU is a really strong jurisdiction in terms of protecting privacy and data, and you can actually litigate a breach of privacy, which is not so much an avenue in Australia, and this is because of the human rights framework that the US has, where you can say this automated system has breached my right to privacy, and take it to Strasbourg, the European Court of Human Rights. And that's what they did in the Netherlands, and that brought down the automated system there, Siri, for the welfare, because they said that, this breaches the right to privacy. So we can see more sophisticated systems in the EU as well, in terms of the AI Act that they're developing. So the EU is developing these controls that will require impact assessments for high-risk AI use. And there's really strong transparency requirements there as well. So there's a transparency standard where there's a public website that publishes all the use of AI across government. We don't have that in Australia. We don't know what kinds of automation or AI is being used in the whole of the Australian government. But if you have a system that has a transparency register published online, that will enable people to know what is happening. We are living in the complete vacuum at the moment.
Janet McCalman has a question about using AI for avoidance of sensitive judgments, Janet? Would you like to?
Terrifically interesting talk, Yee-Fui. Thank you very much. The thing which scared me was the use in the courts of making judgments about reoffending and so on. I mean, this is terrifying, because no matter how big their database is, if it's neurogenerative, then it's going to be relying on the existing stuff it's already got. And in fact, what that does, generation after generation, is impoverish the decision. But you're getting no fresh view, but it's also a complete denial of human responsibility. At some point, human beings have relationships with each other. Are we to do it all through machines in the future? Of course not. But this is so cruel. This is it's a psychopath's paradise of being able to rule people, control them, and make decisions about them with no moral base.
Yeah, it's certainly
Am
a
I
troubling
overreacting?
phenomenon. No, I think it's really troubling. I was really surprised when I went to the US and I realized that they're using AI to predict whether people are likely to reoffend and give each person a score, and the judge makes a decision based on that. That's quite the extreme use of technology, and it fundamentally affects people's liberties. And, there are arguments that, as you said, there's discrimination and bias built into, if you put in bias inputs into the machine learning or algorithm, it'll generate bias outputs as well. And yeah, this is something that is very troubling, and that's why I think we need to put in a lot of safeguards before we deploy this technology to a whole bunch of vulnerable people.
Well, it's actually, if I may be very politically incorrect, it's actually enabling people with a known disability. You're making your society autistic.
Yeah, it's sort of making everyone reliant on computer predictions.
And there's no emotions, no empathy, nothing that we recognize as being human in terms of feelings, relationships, imagination, and this is a new form of absolute tyranny if we don't be very careful.
Yeah, exactly. Like the design of the social security system, criminal law system, there's all these rigid rules. And the reason that we put in humans is that idea of discretion and, individual empathy and taking into account individual circumstances, which may not happen if you have just a computer spitting out the numbers.
Thank you. We have a couple of raised hands here. Mia Gento raised her hand first, and then I'll pass to you, Michael, Mark, after.
So hi, I'm a forensic psychologist, and we already use actual risk assessments to give a number that takes out all of the emotion, because it's actually a better form of justice, because it's more effective, it's more accurate. So we used to have a system where it was pretty much how you feel, taking into account their background, taking into account relationship with a mother, how they might present. But then a bunch of researchers actually looked at all the different variables associated with offending and reoffending, and they use factor analysis to derive a set of variables that we can then use as risk assessments depending on different kinds of behavior. So you would have violence and sexual offending as kind of different. So you'd have different identified variables, and often they're collateral information where you're not even using the information from the offender. Sometimes you do, but other times you don't need it. So judges, we provide them with a high risk, medium risk, or low risk of reoffending. And it is our job to say to the court, hey, these guys are too risky. They need to have, sex offending treatment in prison, for example, or they have to have a violence, treatment in prison, or it might affect their parole. But it's already happening, guys. We already use a number and it's better. It's more accurate.
Yeah, so you raised a important issue that is, let's say we've got a system of mass adjudication where you have to make hundreds of thousands of determinations a year for visas or social security or, criminal judgments. So then how can you ensure consistency of decision making across a lot of different individual adjudicators if they are humans, say? And what you say makes sense. So if you give certain guidance in terms of policy or, risk.
No, it's individual. It's actually, you actually do the assessment on the actual individual.
Yeah.
So it's not making like a large generalized determination. It is for that individual.
Yeah, so individualized assessments that use a risk assessment framework.
Yes.
It's also defensible, right? Because you have to assess the individual in some way. And if you can do it consistently across different decision makers, then that's desirable. And you can sort of extrapolate that to like if a computer was making that decision, we want that consistency, but also accuracy, and you want to be able to trust what the output is. And I think in the sense that controls that we put in for humans in terms of managerial controls, like risk assessment, performance management, auditing of samples of decisions, that can be applied to automated decisions as well. So I think, the issues that we face are quite similar. If we have, we don't want to have one judge having a 99% approval rate, one judge having a 3% approval rate. That means that the outcome you will get depends on who you get as a judge. So that's what they call refugee roulette in Canada, where the approval rates were so different, it wasn't consistent. So we have to impose controls, right, for human decision making and also automated decision making. And I think the same types of controls can be applied across the different types of decision making in order to achieve what we want: consistent, accurate, and
based on the research
decisions. Yeah,
it has to be based on research.
Yeah, exactly.
But the research can be flawed, and in fact psychology's come up very badly in reproducibility.
Yes, I've seen some of the
it really is a serious problem in psychology as a discipline, that very few of the stuff can be reproduced and be scientifically sound. So, it's a question mark too.
Well, to get funding for behavioural programs, like offending behaviour programs,
well, then you're correct.
We have to collect data on recidivism. So, and rightfully so, we must be defensible in our practice, especially if we're going to be getting money and if we're going to be.
Oh yes, it's all about funding. That's what is wrong in universities. Everything driven by funding.
Well, when you're working in a prison or a community setting, you can collect, data on whether that person has reoffended, and we have to do it at like 1 year, 2 years, 5 years, 10 years, so that we compare those groups that have done offending behaviour treatment to those who haven't done it. And then that's one way of being defensible. I agree with you. We need to be defensible, and there have been areas in psychology where that hasn't been so. Yep.
Thank you. Mark, you have been patiently waiting.
No, thank you. Sorry, the talk was really interesting. It's very important subject matter. I sort of want to pick up from where Mia was. So I spent many years working in the Department of Social Security. Computers have existed there for 50 years. So the rate calculator in Model 204 has calculated people's income support payments for 20 years, and it is, as you described it, purely rule-driven. And there are things that are basically calculations, and you can use computers to do them, to do the work very efficiently. But then there are some areas where, as Mia was talking about, judgments come into play, people want to try and get consistent decisions. And so things that I've dealt with are like ESATs, employment assessments, where you pump data into this algorithm and it determines how much employment assistance you can get based on its view about the likelihood of you getting a job, you know. And then for disability support pension, we try and add up your impairments to see if you reach the threshold so you qualify for disability support pension. So where am I going here? You've got a sort of continuum of stuff that goes into from calculations to tools and aids to stuff that goes all the way to AI, where a computer is making judgment. Now, isn't the task for you to try and define at what point do we get worried about this stuff? You know, what characteristic, what criteria do we use to say, okay, at this point, we need to start thinking about this, and is it a problem? And put in place regulations so that it doesn't have the adverse consequences that you're talking about.
Yeah, I think that's right. And I would advocate a risk-based approach with a higher level of regulation and controls for higher risk use of automation. And, certain things are uncontroversially automated, such as if it's a positive determination, so you're granting the visa. So if you automate positive determinations, that's less controversial than automating a negative determination. No, you're not going to get this visa. No, you're going to be evicted from this country. So I think that a risk-based approach to automation and regulation is a good way to do it. And that's what they're doing in Canada. That's the approach they are setting up in the EU AI Act as well, to try to assess the risk of the technology and then impose stronger controls for higher risk systems.
Yep. Thank you. So Ryan has has a question, actually two very interesting questions. Ryan, do you want to ask them?
Hey guys, thanks for the talk. It's been really, really interesting. I think the first part of my question was probably covered already, so I might skip to the second part. Do you see in this technology, do you see any opportunities for organizations outside government to use that in ways that could increase public participation, draw people in, and maybe surface things that government isn't seeing? Yeah, is there ways that we can use this also for good?
What I saw in the US was that the NGOs and legal aid and the sort of AI litigators, they actually band together and they give advice to each other on how to challenge the deficient technology. So in the US, different states implement the social security systems and they blow up in all these different states. And you see the interest groups, they have gathered together to a benefits tech hub, and they exchange ideas. They team up with technologists as well, and they are able to get this data and run it through, the the system that the technologists have built to show the error rates and so forth. So I think that's a very promising avenue that we have seen come from the US, where lawyers, policymakers, and technologies, they all come together to try to, in this case, challenge the decision making. But in the US as well, what you see is the government starting to consult more with academics, IT experts, the affected populations while designing the technologies. So I think that is a very promising avenue forward if the government reaches out to a whole range of different people when they're designing the technology and testing, you know, the ideas and the impacts and the use of the implementation before the implementation is rolled out. So that, I think, is a potential positive step that you can start to see coming out in the US. And if that is systemized, where the government always consults before rolling out the AI technology or consults during the design, that might lead to broader public participation in the processes of government.
Yeah, so I guess there's a sort of corrective element of outside civil society and interest groups playing a corrective role to improve those government algorithms. But is this a technology that can be used for those organizations themselves to sort of advance their voice, or is it really something that is a centralized system that's always going to be kind of centrally government run? Does that make sense?
Well, I guess government uses the technology for many different things. What I've talked about is the adjudication and enforcement, but it's also used to deliver services like, you know, using chatbots, or it's used to facilitate different things as well. And I guess the civil, I guess when you look at the way governments run their policy-making and decision-making processes in Australia, there's a lot less participation than, say, the US and the UK. In the US, they talk about rulemaking as well as adjudication, where there's a lot of public participation in rulemaking and policy-making processes, and the public has a greater say in all these formulation of policies than we have in Australia. Same to be said in the UK as well. There's a greater inbuilt system of public participation in policy making. And I think we can incorporate that here as well. We've got quite a similar system of democracy. So why can't we have more public participatory processes in policy making, government policy making and decision making is certainly something that we do see overseas.
Thanks so much. That was really, really great. Thanks.
Yeah, thank you. I'm going to read a question here because I think the person is not here. Actually, it's from two different. So how do we address the inherent biases of AI, given that they are trained on data which may self-carry historical biases? And how do we address the challenge of inherited biases in AI, especially when the training data may reflect societal biases? So the same question, basically, from two different people.
And yeah, that's really a crucial question. And when I've looked at so there's the issue of when there's a machine learning system, you put in, the bias inputs, it comes up with bias outputs. And then can you challenge that based on anti-discrimination principles? And it's difficult, actually, when you run it through the anti-discrimination test in the US, UK, and Australia. It's not likely to succeed on that basis. because governments don't intend to discriminate. So a test based on intention doesn't work. It's very hard to prove discriminatory impact as well. So yeah, challenges based on discrimination are very difficult to get up. We're still waiting on some outcomes of cases in the US. Australia has extremely weak anti-discrimination laws, so it's never been challenged on that basis there. Another question is the technology. So can we actually extract the biased data? And when you read the literature, some people say it's possible to, you know, like flag certain things or unflag certain discriminators, like in terms of race, sex, religion, and so forth. Some people say, no, it's not possible to extract that. There's still proxies for bias, like someone's address might show their socioeconomic situation, something like that, an indirect proxy for it. So it's quite a vexed question, and I'm not sure we've got the answers to date, and the legal system doesn't really work to address discrimination for AI systems.
But it is present, that has been verified, the type of discrimination, or it's still?
I haven't seen a successful challenge yet.
Okay.
In any of the jurisdictions. We're waiting for some outcomes for cases that are adjudicated but not decided yet, so we don't have the judgment yet. So I haven't seen one that has succeeded so far. Whereas privacy ones have succeeded in the UK, and rationality challenges have succeeded in all jurisdictions.
I think we are almost almost time to close, but Peter Creek, he has here a comment about courage to give advice that government doesn't want to hear. Do you want to make a question about that, Peter?
Well, hi. Look, took me by surprise. I didn't expect you to make a comment on that. I'm throwing a lot of effort into, having worked in Centrelink, seen the Robodebt, knowing people through the process of Robodebt, understanding that it was going wrong, going badly, and should be stopped, and then being asked to double down by the government to do more. I mean, the people were just absolutely spitting chips within the department, not wanting to do this. It's for me yes, the automation and the or the AI wasn't really AI. The automation was wrong. It should have been stopped. It should have been reviewed. Shouldn't have continued, but the government doubled down and continued. So the problem has been that back in the days of the Howard, removing tenure from the top public servants and putting in these yes people at the top, who then push that yes version down into the public service. We end up with a public service that just has no guts to tell the government, sorry, this is wrong, we shouldn't go ahead with it.
Yeah, I completely agree that the removal of tenure of the departmental secretaries has completely weakened the public service, and the rise of ministerial advisers. So yeah, we don't have a public service that does give frank and fearless advice anymore, and the Robodebt situation illustrated that. And I think it's true that, people say it's not so much the automation. Of course, the automation was flawed. They said 95% of people the income averaging method wouldn't work for 95% of the people. So, it was never going to work. But the choices were made by all these people in power, the ministers, and then the senior public servants just being complicit and hiding all the inconvenient evidence otherwise of the illegality. So they knew it was a flawed system, and they persisted, as you said, for 5 years. It's just unacceptable.
And one last question. Joe is would you like to ask your question? You actually start here by, I wish to personally thank Ms. Ng for her tremendously informative talk and ask a question. So do you wanna
No, no questions, thank you. Just read out my message, please.
Oh, okay. And the importance of government in regulating AI bodies. Please advise who the leaders are in private industry who advise governments. I am a victim of the Robodebt. I think Australia is a leader in technology, and we are grateful for the Five Eyes watching over us.
Yeah, it's a terrible system. You know, the social security system in Australia is very punitive. It's difficult to navigate, and purposefully so, you know, like they hide their numbers, and some numbers you ring and it just hangs up on you. It's a deliberately punitive system, I would say. And it's a really terrible way to treat people, the way they have done with all the Robodebts. And unfortunately, it is a trend that we have seen in these advanced liberal democracies. And yeah, it's a big shame. And the government, I hope they really look at themselves and change their ways, because yeah, we do not want another situation of Robodebt again. We need to put in the relevant safeguards to stop that from happening again.
Excellent. Thank you so much, everyone who made questions and participated here with comments in the chat. It was very lively today. And thank you so much to our speaker, Yee-Fui. It's been wonderful